all. Welcome to the International Seminar on the Law of Artificial Intelligence. This is a seminar organized by the Logarithm Association, an association of research on AI and law. Today we are going to discuss and we are going to be focused on the law of AI. This is an event which follows the Icail, the International Conference of Artificial Intelligence and Law, where we have discussed many issues, and the majority of them related to the application of artificial intelligence to legal practice. A minority of the papers presented at Icail was dedicated to the law of artificial intelligence, legal implications of artificial intelligence, or the regulation of artificial intelligence. And that's why we organized this event to focus on this issue, which is particularly pressing, not only worldwide and in Europe, where there is a proposal of AI Act, but also here in Brazil, where there is also a proposal for a bill on artificial intelligence, which was already approved by the Congress and now is in the Senate. Today, we're going to approach different perspectives on the law of artificial intelligence. We are going to begin with Miriam Wirmer, Director of the National Data Protection Authority, and she's going to discuss the interpretation of automated decision-making in Brazilian data protection law. She will be followed by Giovanni Sartor, who is professor of the European University Institute, who is going to extend this discussion on data protection, but now with regard to the general data protection regulation in Europe. After that, we are going to discuss directly some issues regarding artificial intelligence, beginning with Lauren Spindola, which is associated is representing the Brazilian Association of Software Companies, which is going to give an overview. She's going to give an overview on the corporate perspective on the ethics of AI. She will be followed by Juliana Bruzio from Mackenzie University, who is going to talk about the Brazilian proposal of regulation of AI, in particular discussing a difficult subject which regards responsibility for damage caused by AI, which will be specifically the topic explored by Professor Georg Borges from the University of Saarlandes. But he's going to detail the European proposal on the regulation of responsibility for AI. And we are going to close our session with Carrie Hyde-Vamonde, which is going, her talk is going to approach this other perspective, which is the application of AI to law, but she is going to emphasize a particular application of AI, which is the application of AI to judicial systems, an application which has several implications to legal practice. So without further ado, I thank you all for participation in this seminar, and I will now open the floor to Miriam Wirmer. Thank you very much, Miriam, for joining us in this event, and please, the floor is yours.
Thank you very much, Professor Giuliano. I'd like to begin by greeting my fellow panelists and by saying that it's truly an honor to share this panel with so many distinguished speakers. So thank you very much for your kind invitation. And I hope that I can provide some food for thought also on some aspects here of our Brazilian scenario regarding automated decision-making. I think it's important also to make a quick disclaimer, because although I am currently a director at the Brazilian National Data Protection Authority, the opinions that I will express today are my own and do not necessarily represent the point of view of the Brazilian government. As many of you may know, we are headed by a board of directors. There are 5 directors. I'm one of them. So my opinions can, of course, not be considered to be the opinion of the national DPA. Of course, I will speak about data protection, but not as a representative of the Brazilian government, but perhaps from a more academic perspective. And finally, one last disclaimer, I am a lawyer and a professor of law, so I'll ask you kindly to forgive any mistakes or any slips I might make when speaking about the more technical aspects of AI. So as you were mentioning, Professor Juliano, the main focus of my talk today will be the issue of human intervention in automated decision-making, which is a topic that has certainly generated lots of discussion over the past years. And I think it's very interesting to kick off this debate by noting that there has been a growing trend of including in data protection laws or in international declarations the provision that individuals have a right to human intervention in view of fully automated decisions. And this right is sometimes associated to the idea of a right to an explanation or a right to challenge or to have a human revision of such automated decisions. So today I'd like to begin by discussing some of the aspects of AI which make this right simultaneously very important, but also very difficult to implement. And in particular, I'd like to focus on some of the differences and similarities between the European approach and the Brazilian approach to this issue. I'm sure Professor Giovanni will provide very updated and relevant information on this, so I'll just briefly touch upon the European topics. And also, I think it's very interesting for us to begin discussing some ideas on criteria which might be considered in order to identify if human intervention is in fact necessary or not, and what meaningful human intervention could mean in these different contexts. So before actually examining the content of the legal provisions on human intervention, I'd like to start off by saying that the simple fact that these rules exist shows that there is a certain consensus on the idea that AI systems may reach decisions which are culturally or ethically inadequate or simply wrong, mistaken decisions. And there's in fact lots of literature on the issue of AI failures and the different reasons behind this. As I was preparing for this meeting, I was reading a very interesting paper published in 2016 by Mittelstadt, Floridi, and others. And they propose a map of concerns related to algorithmic decision-making. There's also a very interesting paper by Tal Zartke, who also has an analytic roadmap to examine efficiency and fairness in automated decision-making. And I think it's not really important at this point to go into too many details of these classifications, but I do think it's relevant to note that both papers identify, roughly speaking, two main areas of concern. And so just to simplify the discussion, I think we can describe two big groups of problems. The first group is a group of problems related to inefficiencies associated to the quality of the evidences produced by algorithmic decisions. And here I'm referring mainly to results which are inconclusive, unintelligible, or misguided. And perhaps a very practical example of this could be the problem that was very common some years ago with automatic translators. I'm sure many of you have had this experience when we ask for some text to be translated and the result simply does not make sense. These translators have improved enormously over the past years, but this was certainly an issue a few years ago. And in many cases, these misguided or wrong decisions may be the result of a low quality of the input data. So there's a common saying that says garbage in, garbage out, so if there's a problem with the input data, many times you can have also problems related to the quality of the results that are produced, and problems related also to spurious correlations or other problems of this sort. So this is perhaps one big group we could discuss, and the other group which these authors identify could be roughly classified as normative problems related more to the effect of algorithmic decisions over individuals or groups or society in general. And this group of concerns deals mostly with issues related to unfairness. So decisions which are discriminatory or that violate human autonomy. And of course, this is an issue that has been very greatly discussed over the past years. Lots of literature, lots of papers have been produced dealing with the issues of bias, discrimination, particularly in machine learning systems. And I think that the point here is that since these systems, they learn from historic data, they may many times replicate or amplify problems of discrimination, particularly towards more vulnerable groups. And this results in answers or decisions that are sometimes biased, unfair, and discriminatory. And finally, there's a third area of concern, which I think Professor Juliana will be speaking about later on, which is related to both categories and refers to the difficulty of identifying who should be held responsible for AI failures. And this refers mainly to the issue of traceability. So coming back to our point on automated decisions, I think that these two big groups of concerns can also be analyzed in view of the distinction that is sometimes made between strong AI and weak AI. And of course, I do know that some scholars feel that it's sort of pointless to discuss strong AI since we do not yet have any concrete examples of strong AI. But I think it is interesting to touch upon this point simply to state that nowadays, although computers can act as if they were intelligent, simulating human intelligence, they are in fact not capable of thinking or having consciousness or intentionality in the way that human beings do. And I think an interesting example for us to think about is the issue of composing music, for instance. So nowadays we have AI systems which are capable of composing music, which is actually not too bad. And it's usually come upon by, identifying the patterns of successful tunes and which chords go better together. But of course, the process through which a computer composes music is radically different from that of a human being, which involves, emotions, creativity, past experiences, in other words, humanity. And I think that as we discuss AI failures and human intervention, this is in fact an important point to make because it highlights that there are some aspects of the human decision-making process that cannot, at least at this point in time, be replicated by computers. And I point out in particular to the issue of knowledge of culture, understanding of context, emotions such as mercy, pity, or kindness. And of course, I'm not stating that human decisions are always better than automated decisions, because of course, human decisions can also be influenced by unconscious biases, and there's lots of literature on this. But the point I'd like to make is simply that certain elements that can be understood and taken into account by human beings cannot be adequately understood or taken into account by AI systems. And well, this is sort of the theoretical backdrop to the discussion. And I'd now like to move on to take a look at how this issue has been dealt with by legislation. So talking about legislation, firstly, it's important to note that this idea of a right to human intervention, or the right to a revision or to an explanation that can be understood by humans, is becoming increasingly popular. And it's a concept that we see, for instance, in the OECD AI principles, in Convention 108+, in the European GDPR, also in the Brazilian General Data Protection Law. So let's begin by taking a look at the European GDPR, and Professor Giovanni can correct me if I make any mistakes later on. So in the GDPR, we have Article 22 that states that the data subject shall have the right not to be subject to decisions based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. And then we have Article 15 of GDPR that provides that the data subject shall have the right to have information on the existence of automated decision-making, including profiling, and at least in those cases, meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the data subject. So I understand that there is currently a debate on Europe on whether the GDPR in fact provided for a real right to an explanation or only a more simple right to information. And this is due, I believe, to the fact that recital 71 of the GDPR mentions a right to an explanation, but this wording was not actually included in the article of the regulation that deals with this issue. But when we look at this wording, I think a number of questions can be raised, beginning by the first one: what is in fact an automated decision? What is a decision for the purposes of the GDPR? And secondly, what is a decision based solely on automated processing? What is the level of human intervention which would make this decision not qualify under Article 22 of the GDPR? What are legal effects, and what does it mean to say that a decision should similarly significantly affect the individual? What are these significant effects? How should we measure this? How should we, in concrete cases, understand if there is or if there is not a right to human intervention? And of course, I know that Working Party 29 has provided some guidance on this issue in 2018, stating that human intervention must be meaningful and not merely symbolic. but I still feel that there are many open questions as to what does this mean in practice? What is a meaningful human intervention? At what point during the AI life cycle should this intervention take place in order to be meaningful? When we look at the Brazilian scenario, we have some similarities and some differences. So in Brazil, the LGPD has also in Article 20 the provision that the data subject has the right to request a review of decisions taken solely on the basis of automated processing of personal data affecting his or her interests, including decisions aimed at defining his or her personal, professional, consumer, and credit profile or personality aspects. And then paragraph 1 of the same article says that the controller shall provide, whenever requested, clear and adequate information regarding the criteria and the procedures used for the automated decision respecting commercial and industrial secrets. So the language is actually not very different from the European language, but there are some important points that we have to make. So we have the same questions. What is a decision? What is a decision based solely on automated processing? But also, what does it mean to say that a decision affects the interests of an individual? If we look closely, we see that in Europe, the wording is much more precise because it mentions legal effects or significant effects on the individual. And here we have only automated decisions that affect the interests of the individual. So which interests are we speaking about, in fact? Would a recommendation system, for instance, that does not really provide for any concrete actions but offers possibilities affect someone's interest in terms of enabling a request for a revision of this automated decision? So I think this is something that is still open to discussion here in Brazil. And also here in Brazil, there's even a more basic question which needs to be answered, which is the following. Does the right to revision necessarily entail a human revision of automated decisions, or could we accept an automated revision of an automated decision? Now, I realize that this discussion may sound very strange from a European standpoint, because as I understand, the European discussion on the right to human intervention is in fact a right to challenge an automated decision through a human standpoint, right? So we have the right to an explanation which could be understood by humans. We have the right to challenge solely automated decisions. But here in Brazil, this was in fact a very controversial topic as the law went through Congress. And in fact, the wording of this article was changed several times. Originally, the Bill of Law mentioned a right to revision of automated decisions by human beings. And then a first change happened, different wording was proposed, stating that the National Data Protection Authority should provide regulation on which circumstances could entail the need for human revision, considering the economic characteristics of the data processing agent and also the volume of data processing activities, which are not really great criteria when you come to think of it. And then this wording was changed once more. Now we have this general provision that there is a right to revision, a right to challenge automated decisions, but there is no more mention of the right to human intervention. So I think that when we look at the GDPR and the LGPD, we can see that there are important differences, particularly here in Brazil. We still have to face the issue of human intervention, to which extent, when, why, but there is one important commonality between both laws in regards to automated decision-making, and this is the fact that both of these laws condition the exercise of these rights to challenge a decision, be it by human beings or not, to an assessment of the effects of the automated decisions on the data subjects. So the GDPR states legal effects or similarly affects the individual. The LGPD says when a decision affects the individual's interests. But I would argue, in fact, that this is still too vague for us to reach a decision in concrete cases on whether human intervention is or not necessary and what meaningful intervention would look like in specific contexts. This is still not enough, I think, and I think that it's important also for us to understand that when we discuss human intervention, this is not a yes or no scenario, human being in the loop or out of the loop, but it's also a discussion on when and how this human intervention should take place in order to be meaningful and significant in view of the concrete context in which this AI system is deployed. And I think there are several interesting examples to be discussed: autonomous vehicles, lethal autonomous weapon system, recommender systems, and each of them have different specificities. And I think it is in fact necessary for us to dive deeper in terms of seeking to understand which criteria we could identify to help us make these decisions on the need of human intervention and what this would look like in concrete cases. So I think it's important for us, as a society, as an academic community, as government agents, to further discuss which practical and ethical elements could be considered to necessarily attract the need for meaningful human interventions, which I would, include the right to an explanation, the right to human revision of automated decisions. And I would suggest that possible criteria could include not only the effects of the decision, as the LGPD states and the GDPR states, but also the present and future risks which this decision brings to the data subjects, and also the nature of the decision in itself. And I was mentioning earlier that there are different groups of concerns. Some are related to the quality of the evidences, others are related to unfair outcomes. And I would argue that especially when we have decisions where right and wrong are uncertain or depend on perceptions and understandings that computers are not able to replicate, where the lack of sensibility towards culture or context is an issue, that these are decisions where human intervention might be ethically mandated. How do we reach these criteria? I think this is still an open question, but I do believe that impact assessments are an interesting manner for us to evaluate these risks and also understand if human intervention is necessary and when, during which moment of the AI life cycle. And I note that Alessandro Mantelero has an interesting paper where he proposes an impact assessment that is much larger than just a data protection impact assessment, but a human rights, ethical, and social impact assessment, which includes in some cases creating independent committees of experts to discuss the more challenging ethical questions. So finally, having presented all these ideas for discussion, I'd like to argue that, propose for discussion that the idea of human intervention is not really an end in itself, but in fact, it's more related to the idea of achieving legitimate and trustworthy decisions by AI systems. And if we can agree on this, then the result would also be that other elements such as explainability, auditability, and other elements of this kind could also play a role in promoting trustworthy AI. And this, in some cases, could lead us to the conclusion that human intervention is, in fact, not necessary or not necessary at such a deep level as we could imagine, for instance, in particularly risky cases. So to conclude, I think my time is practically running out. I would say that our challenge is, in fact, to deepen this discussion in order to allow us to agree on these elements. And also, I would conclude by saying that if we don't face this discussion, if we don't face these challenges, the largest risk is perhaps that of losing valuable opportunities of using AI in order to improve our society and generate value for the society in general. So thank you very much, Professor Juliano. I very much look forward to your questions and also to hearing the other speakers. Your mic, Professor.
Thank you very much, Miriam. It was excellent as well as always. We didn't receive questions from the audience yet, but I have two questions. The first of them, we know that a human decision based on a profiling, for instance, is not an automated decision-making as conceptualized by the law, both European and the Brazilian one. I have, this is exactly my question. Because recently there was a case in Germany where one data subject questioned the Schufa, which is the credit scoring in Germany. And the question that he has posed was exactly whether the profiling, which is related, the result of Schufa, if this profiling by itself is an automated decision-making and therefore should be protected by the same rights of human intervention, explanation, etc., etc. And if you look carefully at the wording of the GDPR says that automated decision-making, comma, including profiling. That means automated decision-making, which includes profiling, is subject, etc. But our law says the automated decision-making, then it says including decisions by profiling. And somehow it goes closer with this questioning by this German data subject, which is now is going to be discussed by the European Court of Justice. But it seems that there is room in our text, the Brazilian data protection law, to understand that the very profiling would be one sort of automated decision making. So I would like to hear about it.
I think it's a very interesting point, Professor Juliano, and I'm not familiar with the Schufa decision, but I will certainly look into it. When I look at Article 20, I get the feeling that we are in fact discussing mainly automated decisions and not only profiling. I would say profiling within the context of automated decision-making, because this seems to be the general spirit of the article. And also, and when we look at the other articles, when they say, for example, of the possibility of auditing by the national DPA and so on, it seems to refer mostly to automated decisions. But I do think that there is an interesting point in your question, which is the following: does the simple existence of a profile indicate that a decision has already been taken? And what if this profile is then analyzed by a human being, then the human being acts upon this profile? Would this be a fully automated decision, or would human intervention already have been achieved? So I think there's certainly food for thought in your question, and I don't have a definitive answer right now, but I see that Professor Giovanni has raised his hand, so perhaps he has an answer.
Get some clarification, or it's muted, Giovanni.
Now, I would like to follow up on that. I think that, as you said, the GDPR is not clear on the connection between profiling and automatic decision-making. My view would be that profiling is a broader notion that covers any kind of inference and also the content of a decision. So profiling, certain kind of profiling may be viewed as automatic decision-making, but not all profiling. In particular, the profiling that is done by recommender systems advising for advertising would not fall under Article 22 because there would not be a sufficient they would not impact sufficiently on the interest of the data subjects. So this would be why receiving a recommendation would not count as an instance of automatic decision-making according to Article 22. But and then obviously the profiling that only ends in an assessment without any initiative being taken also would not count as automatic decision-making. When on the contrary, the kind of inference that is done based on the data of the individual ends up is the content of the decision, then no, I think you would have a profiling that also is an instance of decision making, I think. But at least this is my view of the GDPR. But
okay, and we have a question by the audience. The question is, since the Brazilian wording in the data protection law is broader, as it mentions that any automated decision making which affects the data subject interests without further detail about it, they ask now, the audience asks whether accepting right to human intervention in the Brazilian law wouldn't be too restrictive and prejudicial to organizations.
Right, so I think this is a great point. And in fact, as the question mentioned, there is a difference between the GDPR and the LGPD, because the LGPD is simply very broad and not precise at all, and just mentions affects interest. So what does affect interest mean? And Professor Giovanni was saying that a recommender system for online advertising, for instance, would certainly not qualify under Article 22 of the GDPR. But in Brazil, under Article 20 of LGPD, this perhaps would affect someone's interests, right? So would this entail a right to human intervention And I do think that in this case, it's too much. It doesn't make sense for us to think that every ad I see when I go on the internet would entail a right to human intervention or to have this decision challenged and evaluated by a human being. So this is actually the point I was trying to make during my presentation, because I think that since our wording is so vague and since we have so many different scenarios of use of artificial intelligence and automated decision-making that range from very risky scenarios such as autonomous vehicles to very simple and common applications such as online advertising, it is in fact necessary for us to specify these criteria in which human intervention would in fact be necessary and in which cases it could certainly be left aside. And I think that perhaps the discussions that have already been carried out in Europe can certainly help us. But I would argue, I think that even in Europe, there are still issues that are not quite clear and, perhaps need for further guidance or further interpretation on what this means to significantly affect someone's interest. So I think there's certainly an agenda for academic research and also for legal discussion here in Brazil. And I do think that Article 20 does not entail a right to human decision in all cases, but certainly in some. And I think our challenge is to find out which cases are these.
Great, thank you, Miriam. And now I move to Giovanni to deepen the discussion regarding the European legislation. Giovanni, please, the floor is yours.
Okay, thank you very much. Let me share the screen. Just a second. So now it will be difficult for me after the presentation by Miriam to go deeper, because she went indeed very deeply into the issue of Article 22, the automatic decision making. But I will be, unfortunately, I will be unable to go deeper than her. I will be more superficial, but I try to cover maybe more broadly the relations between artificial intelligence and the GDPR. So let me share my screen. Okay. So you should see my slides now. Okay, so okay, I will try to give you a quick overview of the connection between the GDPR, the European Regulation of Artificial Intelligence, and artificial intelligence, and the European Regulation of Data Protection, and artificial intelligence. So data protection is undoubtedly at the forefront in the regulation of AI, because as you know, many applications of AI involve the massive processing of personal data, the targeting, personalized treatment of individuals. But I don't know, other domains of the law are also involved in the regulation of AI, from consumer protection law, competition law. So we should not address the regulation of AI only from the perspective of data protection. As we know, in Europe, and from what I hear also in Brazil, there are plans to provide legal regulation of AI in general, and not focused only on data protection. But as where we are now, and also in the near future, I think the data protection is the legal, the domain of the law that most directly deals with AI. And the GDPR does not really speak about AI. You cannot find in the GDPR any terminology such as artificial intelligence, intelligent systems, machine learning, none of that. But the GDPR contains various provisions that are that deal with AI, and I think that it can be interpreted and applied so as to address the risks and allow for all kinds of beneficial uses. I think that the kind of concerns that were raised by Professor Miriam are not really addressed by GDPR, because also GDPR is a very broad and general, it includes very general clauses that fail to, for instance, to decide what interests are more or less sufficiently important to justify limitation to automatic decision making, and many other issues are not addressed by the GDPR. So it's up to to lawyers, to the data protection authorities, to judges, to academic lawyers, to try to specify the content of the provision in the GDPR so that they are appropriate to AI. But I think that this can be done. So a lot of guidance, I think, is needed to apply the GDPR to AI, but I would say it's not an impossible task. Let me just mention a few problems. So a few problems that raises with regard to AI is the very idea of personal data. Why this is problematic? Because according to the GDPR, personal data includes any information related to individual which is identified or identifiable. And to determine whether an individual is identifiable, account should be taken of all means reasonably likely to be used. So what is the, how does AI affect the very notion of personal data? I think there are two issues. First of all, AI may enable the inference of new personal data from the personal data that are available. And secondly, it may enable the re-identification of de-identified personal data. So with regard to inference, we may wonder whether the inferred personal data are new personal data that according to the GDPR. So for instance, when based on the data of a certain individual, you have a credit bureau that infers, that assigns to this person a certain level of creditworthiness, this is arguably an additional personal data, the piece of personal data that is added to the data on the basis of which the inference is performed. And similarly, when you have, I don't know, a radiography of a person on the basis of which there is an automated inference that this person has a certain kind of health issue. A certain pathology. Again, this is a new personal data that is added. And so should this inferred personal data, piece of personal data be considered indeed the personal data according to data protection law, triggering all implication of data protection law, even when this inference only is probabilistic. And I think that the problem I believe should be answered affirmatively, at least when this information is going to be preserved and used for possible decisions affecting the individual. And then there is the issue of re-identification. So AI can be used to reconnect anonymous data to the individuals to which they refer. For instance, in the medical domain, consider a radiography or a scan of a patient without the patient name. Is it a piece of personal information or not? It depends on whether there are reasonable means the patient may be identified normally through reasonable means. And this also may be a difficult judgment. I think we should not be too strict. So it is not the abstract possibility of identification that matters, but whether identification is likely. If we consider the abstract possibility, and every piece of data would become personal. I think we must be reasonable, and this is also a task for legal interpretation. AI system, as we all know, are a prediction or profiling machine. They learn a model, at least in the machine learning application, they learn a model that links predictor values, for instance, in the medical domain, the shape of a radiography, the image in a radiography to the target that can be the diagnosis or prognosis for the patient. Clearly, when the model is applied to an individual, it is both the data for making the prediction are personal data. For instance, I mentioned the medical data, but you can also consider the case in which creditworthiness or the likely of recidivism or whatever are predicted. When instead the data are in the training set, these are also personal data unless they are anonymized. let me now come to another notion which is quite important in the GDPR, which is the notion of profiling, as was mentioned in the previous presentation by Miriam. So using, which consists, according to the GDPR, in using the data concerning a person to infer information about that person. So to make another line in the picture of that person. This is a very broad notion according to the GDPR. Obviously, profiling may be beneficial or not beneficial to the person. So you have profiling when you infer the health status of a person in order to subject this person to a therapy, but also when this inference is made for determining the insurance premium for this person, and therefore by raising the amount that this person is going to pay in case this person is likely to have some health problems. Profiling is addressed in the GDPR, on the one hand in connection to the automatic decision making, but as I said before, not all instances of profiling involve automatic decision making. On the other hand, we may wonder whether all automatic decision making involve profiling, and in this case, the opinions are not. There are differences of opinion. I would say so probably that all automatic decision making according to the GDPR involve profiling, while the converse is not the case. Since I don't have much time, let me just go quickly through the data protection principles and artificial intelligence. So AI challenges some data protection principles. What are they? So first principle is the idea of purpose limitation. So which is included in the GDPR, Article 5(1)(b). Data should be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with such purposes. There is some exceptions to that. For instance, further processing for scientific purposes is not considered to be incompatible with the initial purposes. So data collected, for instance, for the purpose of taking care of patients in a medical environment should legitimately be used also for scientific research into the medical domain at issue. Obviously, this must be consistent with the necessity principle, which is another principle of the GDPR. Therefore, it must be necessary that these medical data, following our example, need to be personal, that we cannot perform the same kind of research that we are engaging in by anonymizing this data, by deleting all information that enables reasonably to reconnect this data to the concerned individuals. Pseudonymization is another alternative when anonymization would not be possible because in the medical case, we need to track the patient through the various steps of their issue. Then pseudonymization using codes separately kept rather than patient's name may be an option. Another principle that is a thought, it is in conflict somehow with the idea of with AI is the idea of data minimization. So all data should be adequate, relevant, limited to what is necessary in relation to the purposes for which they are processed. But how can we make this consistent with data analytics? That is the idea that once that you have big amounts of data, again, let us consider the case of medical data, where this is particularly important. You have a vast amount of medical data. Should you throw them away once the patient has been taken care of because they are no longer needed for that purpose, or can the data be kept for purposes, for instance, of scientific research? Also for inquiries that we are going to do in the future that we are not planning to do presently. The idea in the GDPR is that the new purposes, it is not excluded that data can be processed for new purposes, as long as these purposes are compatible. They should not involve unexpected risks for the patient, for the individuals in particular. There is always a possibility for anonymizing data, but maybe also a future processing may justify retaining the data as long as adequate security measures are in place. No, the GDPR often does not provide us with the definitive answers to issues. Also because it is very difficult to provide definite answers. One problem is the problem of the explanation, which was mentioned in the previous speech, but there are many other issues such as that. When can data be retained for future uses? That for which there is no black and white answer. Balancing of different interests have to be done also for interpreting these open-ended clauses. So we cannot expect too much also from a regulation such as the GDPR, and I think also from the Brazilian regulation on data protection. Similar problems, I think, would emerge. Another interesting issue is the issue of the legal basis for processing. What is the legal basis when AI is going to be used? In general, there may be consent, but in some cases there may also be legitimate interest by the controller. An interesting case is the targeted advertising, where probably in Europe there is the view that legitimate interest alone can hardly be sufficient to justify processing for the purposes of targeted advertising. But on the other hand, also consent is not an adequate there are a lot. I cannot go into the issue of consent, but we all know that consent doesn't work in most cases. So how to combine the two ideas, the idea that processing should pursue a legitimate interest that is not outweighed by the interest of the data subject, and on the other hand, having the idea of consent, at least for processings that do not appear to serve very important goals, is still an open issue concerning the GDPR. In other domains, for instance, in the medical domain, there may be specific justifications. In this case, the idea of legitimate interest does not apply, but reasons concerning to preventive or medicine, but also diagnosis, health or treatment may justify under certain conditions the processing of personal data also without consent by the data subjects. The data subject, however, has a right to withdraw consent, not only to withdraw consent, but also to object to the processing. Finally, but I think that Miriam went into this issue to a much deeper extent. There is the issue of transparency. When the data is inputted in a system that is going to process the data for AI purposes, but also after an algorithmic model has been applied and new information concerning a certain data subject has been obtained. And there we have the issue of the right to an explanation, an issue which is, as Miriam said, not clear about the EU law. Probably the idea is that as the law stands today, there is probably we should consider that there is not a right to an individual explanation, also because the current text of the GDPR was the outcome of an interaction between the European Parliament and the European Council and the Council, where Council of Europe, where the European Council, where the a first draft by the Parliament, which included a right to an individual explanation, was then rejected by the Council, which removed this right, which has remained only in one. It is not included in the articles of the regulation. But the issue is uncertain, and also this issue has to be addressed in a reasonable way. We must consider that there is in the AI performance explainability trade-off. For instance, in the medical care, if we have opaque methods that are better in providing, I don't know, diagnosis based on radiographies of scans, I think we should rely on them, even though a perfect explanation of what they're doing cannot be really obtained. But the situation is different in other domains, such as when in the legal domain or in decision concerning appointments, concerning creditworthiness, in such context. So depending on the context, I think that also Miriam said that we may have stricter or less strict requirements concerning also explanation. I think I have been speaking more than enough, and then on automated decision, Miriam went into a much more detailed presentation that I could. So in conclusion, what can I say about the GDPR and AI? I would say that GDPR is not incompatible with the deployment of AI. It can contribute to ensure its beneficial deployment. But there is a lot of work to be done to find reasonable interpretations of the GDPR. And then a big task is upon the data protection authorities and the legal community more generally to find appropriate interpretation, specification of the GDPR that maybe promote the useful deployments of AI while preventing at least the most serious risks. So thank you very much for your attention, and I look forward to any question you may have. I unshare my screen. Okay.
Thank you very much, Giovanni, for your excellent talk. We have a question by the audience. The question relates to this discussion that was put forward by you with respect to the consideration of whether an inference by AI would consist in a new personal data, which should look for a new legal basis, for processing. And the question is whether this interpretation wouldn't hinder the development of AI. So the question is whether the data protection law wouldn't be an obstacle to the development of AI, and if the legislation should be adapted or changed for a broader development of artificial intelligence.
Oh, thank you much for this. This is an excellent question. It's difficult to find an answer. So it seems to me that this must also be interpreted reasonably. So when you have a new item of either the processing of the data for making this particular inference was considered the person was informed about this inference in advance. In this case, the person may have, has already been informed, the person may have the right to access this the outcome of the inference according, I think, to the GDPR. Should the person be informed that this piece of data has been inferred, I think that according to the GDPR, there is the obligation to inform the data subject unless it is particularly inconvenient. So probably you can also in some cases, it may also be argued that there is no need to inform the data subject about the fact that a particular information about them has been inferred. So again, I believe that it is possible to make a reasonable interpretation on the GDPR. And then there is the issue of the legal basis. And the legal basis is not only consent. You may have legitimate interest when the processing is not going to have an impact on the data subject and is beneficial to the controller, to society in general. And then there are also particular exceptions that are provided for processing in, new processing are considered to be compatible with the original processing when they are motivated by scientific research, but also by statistical research. So when they are used for coming to conclusions that do not concern individuals, but have a general character. So no, okay, there is a lot there are ways in the GDPR, I think, to avoid the kind of obstacles to the use of AI that you were that you indicated. But I don't know, I think more should be done to look into this kind of issues.
Okay. Thank you, Giovanni. But in general, I would ask if we looked for if we compare the North American legislation on data protection, on privacy, and the European legislation, which is much more rigorous and detailed and unified, do you think that there are better conditions for the development of AI in US, for instance, in relation to Europe? I'm not talking about trustworthy AI, just AI in general.
Yeah, maybe in China there are even better conditions for developing AI applications. But no, I don't know. Maybe that it is cheaper to develop some application without taking into consideration the issues that they need to apply the GDPR. As I said, my view is that also in the US things are changing. There is this California law on data protection. There are. I think that we must be. My belief is that it is possible to make use of the GDPR in such a way that it is not. It does not negatively affect the use of AI. We must be careful. In particular, there is always the risk of introducing additional bureaucracy, new forms to be compiled. So we must be careful, I think, on that, in particular on the bureaucratic requirement, the format that may be introduced. But I think it is possible to make use of to use the AI consistently with the GDPR without having too many problems. I think one issue is also whether probably there should be also more not in Europe. There is the sometimes we are too strict concerning the use of technology by private organizations in certain cases, at least. This is also something that has to be taken care of. But I'm not pessimist. Let me put it this way.
Okay, Giovanni, thank you very much, because you have made a perfect link to Lauren's talk, because exactly this question about the possibility that regulation on data protection or on AI brings further bureaucracy, to company or to private companies to develop the technology is an issue. It's an important issue for a policy for the development of AI in national strategies or in any proposal of regulation of AI. So Lauren Spindola is now going to approach this issue about the view by the companies regarding the ethics of AI and the perspective on regulation. and policies for the development or the safe development of this technology in Brazil or or worldwide. So thank you very much, Giovanni, and please, Lauren Spindola, thank you very much for your participation in this seminar. The floor is yours.
Thank you so much, Juliano. Thank you for the invitation. Well, after those two great speaks, I will try to follow up here. Well, talking about ethics, basically, ethics is a set of moral principles that help us discern between right and wrong, to be very simple. So AI ethics is a set of guidelines that advise on the design and outcomes of artificial intelligence, to be just as simple as that. But we need to remember that human beings come with all sorts of cognitive bias as well. And those inherent biases are exhibited in our behaviors and, of course, in our data. And since data is the foundation for all machine learning algorithms, it's important for us to structure experiments and algorithms with this in mind, as artificial intelligence has the potential to amplify and scale all the human biases. And well, there are a number of issues that are at the forefront of ethical conversations surrounding AI ethics in technologies. And I'll go through some of them, okay, just some of them, because the discussion is very long. Okay, we were talking, and then Miriam talked about superintelligence and the strong AI. So it gets a lot of public attention, and we must say that many researchers are not concerned with the idea of AI surpassing human intelligence in the near or immediate future. We will take a long time to go there. But despite the fact that strong AI and superintelligence is not imminent in society, the idea of it raises some interesting questions as we concern the use of autonomous systems like self-driving cars. Who is responsible and liable in the case of a car accident? Aren't our current laws enough? So this type of ethical debates that are occurring as AI technology develops are just having floor now. And we need to think about it seriously. So another public perception around artificial intelligence centers around job loss. This concern must probably be reframed. And that is just because every time a disruptive technology comes, we see that the market demand for specific job roles shift. So, and it happened in every industrial revolution. For example, when we look at the automotive industry, many manufacturers are now shifting to focus on electric vehicles because of green initiative. And also the energy industry, they are shifting from fuel to electric energy. So things are just changing, and we need to be open for this shift. And artificial intelligence should be viewed in a similar manner, where artificial intelligence will shift the demand of jobs and in other areas. We will create new jobs. We need to focus on human specialties. We need to focus on creativity, on empathy, on human values, because that for sure AI can't do. Well, as Professor Giovanni and Miriam just talked, privacy tends to be discussed in the context of data privacy, data protection, and data security. And as a result, we have a main investment within security, and it is a priority for business as they seek to eliminate any vulnerabilities and opportunities for surveillance, hackings, and cyber attacks. And also a big issue here is bias and discrimination. We have seen it across a number of intelligence systems, and it has raised, of course, many ethical questions regarding the use of artificial intelligence. So how can we safeguard against bias and discrimination when the training data itself can lend itself to bias? It is really difficult and actually a philosophical question. We have some options here, like having diversity in the team who's training the system, because a more diverse team will not only be more innovative, but it will also help to mitigate bias. And since there isn't significant legislation to regulate AI practices, and Juliana will talk about it in a few minutes, we have no reinforcement mechanism to ensure that ethical AI is practiced. The current incentives for companies to adhere to the guidelines are basically the negative repercussions of an unethical AI system to the bottom line. And this is the strongest as we can go. And here I can make a pause and just say that this is like the new ESG movement. This is like corporate responsibility. People are getting attention to those points as data protection, because if we go for 3 years ago, no one would ever know that, well, my data, what is my personal data? So I think that now we are going on the same path, that we need to have ethical AI because consumers are asking for that. And since artificial intelligence didn't give birth to moral machine, ethical frameworks have emerged as part of collaboration between ethicists and researchers to govern the construction and distribution of AI models within society. And there is some consensus around incorporating governance and explainability. And then here just having the data protection laws, because we had to have a governance team to deal with data. I think that we can use those teams to also deal with AI ethics, and well, they would be responsible for compliance with government governance and government regulations and laws and all. And explainability. Well, machine learning models, particularly deep learning models, are frequently called black box machines. So, and it's usually unclear how a model is arriving at a given situation. And explainability seeks to eliminate this ambiguity around model assembly and model outputs by generating a human understandable explanation that expresses the rationale of the machine. And here it's important to say that I need to understand how the machine got to this answer or this solution. And this type of transparency is important for building trust with AI system to ensure that individuals understand why a model is arriving to a given decision point. And of course, if we can better understand the why, we will better be equipped to avoid AI risks such as bias and discrimination. So here's just saying that the private sector is not against regulation. It's not that. It's that we need to focus on the use of AI, and we are for a precision regulation approach, meaning that we are talking about facial recognition, so we need to have a specific law on that, because it's not, I think that I cannot even say how I can understand someone is trying to regulate a technology that is not fully developed. It's like trying to regulate internet back in the beginning of, we have discussed about it. So just to wrap up, and then because I think that the subject leads to a lot of discussion, I want to say that achieving ethical AI will undoubtedly be important to its success. But it's also important to note that it has tremendous potential to impact society for good. And this conversation on ethics is important because despite we develop the technology for good, we need to be prepared and understand that it has potential for harm. And we need to build trust on the technology so people can use it in this fully potential. And then here talking about trustworthy AI, this is what we stand for. This is what we, and then here I'm speaking about technology companies. That's what we do. I mean, we are building AI for good. We are using AI for medical issues, for injustice, as Carrie will say later, in climate change, in nature. I mean, so many sectors that we are using and improving lives. And but I do think that this is an issue we need to concern and address. And we do have different frameworks as OECD has its principles for ethics. UNESCO has just launched its recommendation for AI ethics. And if you read it, this is all that big companies, the big techs, this is all that we are already saying, that it needs to be explainable. You need to have governance. You need to show when someone is talking with an AI system and not a human being, you need to have diversity. You need to respect fundamental rights, of course. It can do harm. I mean, we do have all the principles that we are in compliance, if I can say, with all the principles that are already there. And we have, and of course, as companies, we do need to sell. And we will only do that if we get trust from consumers and from citizens. So it's our concern to be ethical, and this will be always the main concern for us.
Thank you very much, Lauren, for your intervention. And there are some questions here from the audience, but there is a particular one which I think is provocative and challenging that I would like you to discuss, which is how to, the audience here asks how to ensure that private companies are going to comply with best practice, with the pursuit of these ethical values, or to ensure that these concerns are going to be mitigated. So how should be the approach? Only the trust of the consumers is made, I think, taking the end of your speech, only the trust by the consumers will be enough incentive for the private companies to adapt? Or should there be obligations imposed on the companies, or should only be these principles? I think that is a nice question to discuss also, and to hear your opinion about the Brazilian bill, which follows a model of general and abstract principles.
Okay, yeah, this is definitely a very interesting question. Of course, we cannot expect that only the trust of consumer will be enough. No, we do have models to prove that we have trained our data properly. And well, if anyone asks, a company can do that because we have governance of the data. So I can explain how my AI system got to that decision. This is not difficult. This is not asking too much. And well, and then if you think that you got discriminated, well, we have specific law for that. And you can prove that you were discriminated, and the company can prove that it, well, how the system was trained, and then why it got to the decision. And then, well, this is another discussion. But it's not difficult at all for a company to prove that it has good governance, that it has how they train the data, and explain how the algorithm got to that decision. This is not difficult at all. But I think that it's not only the trust of consumers, we need to show that we're doing that. So I think that by the time it will get there, I'm not sure, I don't have the answer on how we can do that, but if we talk about the Brazilian scenario here, we have the bill that proposes a report. Considering the European proposal for AI that considers a risk-based approach, that it's what we are going here in Brazil, that I think that it works best for this kind of technology. So thinking about high-risk AI, like a system of health, this is different. This is a totally different situation. So I can you can ask me for a report that then I'll just put there all my what I did, all the steps that I did to train this system. So where did I collect the data? Who was the responsible for inputting the data in the machine learning system? From there, did I train the system? Did it? How much did I train it? Did I use it like 3 times or 10 times? Am I secure enough that my system is trust? Another thing, how diverse is the team that you're working with? I can prove that. I mean, did this technology, this system, this AI system, got to another approval that has nothing to do with AI in the company? This is another thing that we can do. Just take it out of the scenario and give it to another different team to have a look at it and see if it's okay, if it makes sense. If they see, well, here we have a risk situation, you should go back and retrain the system. This is things that we can do, and this can be on the report for a high risk AI, and then we can prove that, well, I've well-trained. I'm confident that, I don't know, training 30 times, 50 times, I don't know, it's enough to prove that it's working good. Having a diverse type of data and a well-governed team that will do it and input in the system is also a way to prove and avoid bias and mitigate any risk that it might have. Of course, we need to have in mind that, well, this is a technology and the algorithms will sometime, at any time, work by itself. But we can explain the beginning. I can explain the rationale of the decision. This of course I can do. And then we have different types of AI that, of course, it's more difficult to get on the top of the decision, but the beginning is always possible. And then if I've trained my system in a way, it will definitely keep at least the track of the beginning of the training. So I think that it's a way that we can get there. And again, this is not a black box. We have ways to prove it. Actually, we have softwares that allow companies to see if it's ethics, to mitigate bias. We have already softwares on the market that are able to help us having this decision and making these reports and giving trust for the consumers as well.
Thank you, Lauren. There's another question here. I don't know if you can answer, but you are here representing the industry. So the question is whether it's a common practice already that software companies make impact assessments or risk assessments in the development of software. This is the first one. And the second one is whether there is a movement of, in the sense of creating codes of conduct in different sectors of application of artificial intelligence, because as we know, the European legislation makes indications and creates incentives for sectorial regulations. Then the question then is whether the Brazilian software industry is already taking steps for making risk assessments, developing codes of conduct. So how do you view this moment in the Brazilian industry?
Okay, so we have companies and companies, right? Unfortunately, but well, yes, the majority of the sector is prepared and doing risk assessments. We actually have a law here in Brazil that deals with it. And software companies, they work, well, the biggest client is government. So we do need to be compliant with all legal aspects in the law here in Brazil. And risk assessment is one of the issues that they ask. And another point, if I'm not serious, can I say like that, I will suffer the consequences. So it's in my interest, well, me here as a company, that I'm compliant with all good practice of the market, because I want this consumer to be happy, because then he will, of course, buy more, and well, he will talk about me to other consumers. So I think that everyone wins. I mean, if we have if we have good practice, we do have global good practice. We need to follow them, because it makes no sense to do otherwise. I'll get behind. And so yes, the sector is doing it. The sector is working with risk assessment because the harm is really big. And so I do need to check all my systems. I need to check not only AI, I think, and then I can talk about all software as well. And then, yeah, well, that's it. I would say that definitely yes. Of course, that I cannot confirm that all companies are doing like that, but the majority of the sector, yes. And we do work with the government and with the House of Representatives to help them to make the bill. I mean, again, is in our interest that we have everything settled so we can do our work. So we are working with them, advocating for the sector, and then saying, of course, that if they ask something that we cannot do, we'll say, okay, this I cannot do, but I can do in ethical. I can. Of the benefit of the.
I think we are experiencing, I think Lauren is experiencing some difficulties with the connection.
Am I back?
Yes, you're back.
Okay, okay. Yeah, sorry for that. Oh, technology, see? Yeah, we are improving that. I don't know what part did you miss?
Well, no, you're just saying that you cannot insure, but since it's an interest by the companies to comply in relation to government, then you can say that companies are in this direction of making assessments to avoid problems with technology.
Yeah.
Okay, I think Giovanni has his hand. Giovanni?
No, my question was the following anyway, but a quick one. In Europe, now we are having different rules for big companies and small ones. So the idea is that small companies would not be able to use the same kind of advanced technology or method as the small ones. So we need to have special rules for them. Do you have the same issue also in Brazil, or?
Not for AI, not for now. We had for, and then Miriam can talk better, we had for the enforcement of the data privacy law. But for AI bill here that we have, the discussions have not come at this point yet.
Because
we never know.
That may be interesting. In Europe, we have some rules of this kind in the new Digital Services Act. So it may be interesting to have a look because there this differentiation has been introduced also with regard to recommendation system and AI system. So maybe something to.
Well, the logarithm has made some discussions with the Federation of Commerce, and we have sent to the House of Representatives a suggestion for improvement of the bill, which is under discussion there, where we suggested that there should be facilitated mechanisms of financing small companies in the development of AI using public funds, and also with the opportunity by the government to create sandboxes to development of small companies. Unfortunately, in this round, these suggestions were not incorporated, but this would be some special treatment for startups and for small companies that wish to invest and develop AI.
But if Juliano, if I may, this is not specific for small and medium companies, but the idea is for all companies. Of course, that I do believe that they need to have a different approach so we can leverage their opportunities. But we, of course, stand for sandboxes. And of course, the government needs to focus on research and development and financing. But of course, this is an issue that we need to address and to make sure. And mainly if you think that in Brazil, we are mainly startups. So we do need to think about them, and this is an issue. And thank you, Professor Giovanni. I'll have a look on the Digital Act. I think that we can well, benefit from it for sure.
Thanks.
Great. Now I suggest that we make a 15 minutes break. So then we can, for the last 3 talks, by Juliana Bruzio, by Georg Borges, and by Carrie Hyde. Is that okay? Okay, so we meet here in 15 minutes. Acho que vai dar certinho, vai dar 3h40, daí começa com a Juliana, a Kerry, o Georg Borges e a Kerry Haidt. Oi, Bruno. Certo. Então, a gente pode começar aqui em 3h40, né? Se a Juliana não tiver conseguido entrar ainda, a gente começa com a Carrie Hyde. Hi, Carrie.
Hello.
We are still waiting for Juliana. If she gets a little bit late still, then we switch and we start with you. Would that be okay?
That's fine, thanks.
Okay, let us just wait if she joins our room. If she doesn't, then we switch. Seems that she's joining us now. Bruno, a gente entra no ar já ou espera a Juliana entrar? Tá. Oi, Ju. Oi. Well, hello. We're back from our small break, and we will continue the discussion now that I enjoyed. Until now, I enjoyed a lot, and now we are going to continue with the issue of responsibility and regulation of AI. We will start with the talk by Juliana Abruzio from the University of Mackenzie. So without further ado, I open the floor to you, Juliana. Juliana, thank you very much for joining our seminar. You are muted, Juliana.
Oh, sorry. Sorry. Hello, Juliano. I'd like to thank Professor Juliano for the kind invitation to be here this afternoon. I'm very honored to be here among other specialists on AI. My greetings to Dr. Wimmer, Dr. Spindola, Dr. Sartor, Dr. Borges, and Dr. Vamond. I have some slides to share, Professor Juliano. I'll do it right now.
Please share it. Yeah.
Okay. There we go. Just a second. Can you see it?
Not yet.
Not yet, just a second.
Yeah, now we can see it.
Okay. Okay, so before I go deeper into the text itself of the Brazilian AI view of law, I'd like to highlight what we already have in Brazilian laws regarding AI. First of all, I will mention our Consumer Protection Code. Under its section 39, item A, the supplier of the products or service must introduce in the Brazilian market any product or service in accordance with the rules from official bodies or with Brazilian Association of Technical Rules, ABNT in Portuguese. It turns out that ABNT is responsible for internalizing rules from ISO. And as a matter of fact, we just had from ISO, IEC number 24027 about bias in AI systems and AI-aided decision-making. This one that you can see here in the slide. Therefore, on the one hand, under Brazilian AI bill, there is a principle rule regarding non-discrimination on an AI system and decision-making. On the other hand, ISO, IEC rules, such as the one I mentioned, number 24027, can indeed become a source of law for judicial or administrative litigation involving companies and consumers about bias, discrimination, and decision-making. Of course, as written in the Consumer Code, depends on ABNT internalize this ISO rule. However, this is something that surely is in ABNT pipeline. Also about the Consumer Code. Some cases in law involving AI systems, such as automated decision-making for credits, have already been analyzed by Brazilian's Superior Court. Actually, the case I will mention here that you can read and see the slide, the presentation, deals with credit score decision make, and so with AI technology. The court in 2016 decided the consumer has the right to know what personal information about him, her was valued in their, or process in the automated decision-making that denied the credit. Under the consumer code, a right of explanation was recognized in this case in law, in order to empower the consumer to know which of their personal data were used in automated decision-making. Still, under Brazilian data protection law, Article 20, there is a right to explanation and also a right to review the automated decision. The Article 20 says the data subject has the right to request a review of the decisions taken solely on the basis of automated processing of personal data that affects their interests, including decisions designed to define their personal, professional, consumer, and credit profile, or the aspects of your personality. The controller shall provide, whenever requested, clear and adequate information regarding the criteria and procedures used for the automated decision, observing commercial and industrial secrets, intellectual property. So once again, we verify that we have under Brazilian law a legal protection concerning AI systems, but we do not have a centralized system. What we do have is a decentralized rules under the data protection law, the consumer code, and others. Well, going into the bill of law, the AI Act in Brazil, we have the civil liability. That is the point I would like to emphasize here this afternoon. This is definitely one of the crux of the matter, no doubt, is one of the crux of the matter. Several stakeholders and professors and scholars are discussing and disagreeing among themselves about how would be the proper civil liability for our Brazilian AI Act. But I would like to emphasize that there is a general liability system or theory in Brazil that we cannot put apart, we cannot disconsider it. In other words, under Brazilian civil code, it's established that the rule is the liability for damages, the regular liability, the one that take in account the fault of the wrongdoer. The strict liability, that is the one that disconsider the fault of the wrongdoer, is the exception. There are some situations under Brazilian law that this exception will be applied, such as in the relationships involving consumers, such as relationships involving public authorities. For instance, if the police of São Paulo state, where I live, where Professor Juliano Maranhão lives, starts using AI for public security, it will be a case of strict liability because our federal constitution says so. This rule is already set down. For last, and I'm going for my last part of the speech, on my opinion, the Brazilian AI bill of law should have involved more stakeholders, more discussions. We are going too fast, and there's no explanation for this. We have to calm down and discuss with stakeholders, go deeper in some points and some issues, and open to public discussions in our Congress House in Brasilia. The text of the bill is technically immature still, since depends on a multidisciplinary participation, including experts in law, experts in data science, and in AI. It's impossible to go forward only involving experts in law, for instance. It also needs to incorporate more governance process, governance steps, promoting the accountability principle. This is the how to address AI rules nowadays with deep learning process. It's about governance. It's about logging and registering step by step. Risk levels assessments to raise security and confidence to the users and to the market. Without that, we won't have the necessary confidence from the users, from the consumers, from the market, and from investors. So this is a short pickup of the bill. I'd like again to say thank you for Professor Juliano Maranhão, with who I'm always learning about this matter. Thank you, Professor.
Thank you very much, Juliana, to introducing this discussion about our bill of for artificial intelligence, for the regulation of AI. After you, Professor Georg Borges is going to give an overview on the discussion in Europe about this subject, which he is involved and contributes with several interesting positions and grounds for responsibility and liability of for AI, for damages caused by AI. But before that, we have a question by the audience, but maybe it's better that I explain a little bit the context. Otherwise, others which are not familiar, those who are not familiar, very familiar with the subject may have some difficulties. So what we have in our proposal for AI Act here in Brazil, it's actually, as you know, a very superficial document. It has some general standards about ethical principles. And then regarding responsibility, it's also superficial. It just says that in future regulations, the public authorities are going to use subjective responsibility as a standard, and in those and exceptionally in those cases of risk, it should be adopted the objective responsibility. It is also indicated that in consumer relationships, in consumer supplier-consumer relations, then there should be an objective responsibility, as it is already established in the Consumer Protection Code. So this is the general background. The question that comes from the audience is that the first statement is that the proposal by the Brazilian AI Act actually follows the general systematic of the Brazilian Civil Code. In general, subjective responsibility, and for risky activities, dangerous activities, objective responsibility. And recently, there was an open letter by 25 jurists that was open to the public and sent into the Senate, where the legislation is now under discussion, and questioning this this approach. But the question then is, if this is the general approach followed by the Brazilian Civil Code, why should, the question is whether you agree with this open letter, or in the sense that there should be something different for AI in relation to the general regulation of civil liability in Brazil.
Okay, thank you, Professor Juliano, and thank you for giving me the opportunity to comment about this letter. It's a very important letter with very important jurists, scholars, Brazilian scholars in Brazil. With all my respect, I do not agree with the content of this letter, because we cannot generalize AI results, outputs. Once you read the content of this letter, it's easily to note that there is a dystopic perception regarding AI. Like, what comes from the output, from outcomes regarding AI? And that's not the case. We have several uses regarding AI technology with low risks, level of risks, high risks. So it depends on the level of the risks. Most of the time, we are using AI technology that they are simple with not high risks. So it seems that they are building a thesis or a perception from a very dystopic point of view. And this is not exactly AI. It's not something that we can put always inside this box. So it's, for instance, I have the European model example, the European model as a good one to be followed, to be addressed in Brazil. Because first of all, there are two different documents, the AI Act and another one regarding liability. And the one regarding liability, there is an attachment. And this attachment will be changed time by time, because this is technology. Today's technology, nowadays technology will not be the same regarding comparing to next year. So we have to establish the base, the general legal system for that. And my point of view is that I'm more concerned about how to design how to address the issue, like a liability act with an attachment, considering different levels of risks, than just choosing between a subject or a strict liability, because this is a red set under Brazilian law. We have our federal constitutional, we have the civil law, the civil code. So this is not a crux matter here, but liability on AI, it's a very serious and important issue to be addressed. So this is my point, Professor Juliana.
Thank you very much, Juliana. I particularly agree with you. So we won't have too much discussion about it. The problem with the open letter is that there is a flawed view about the technology underlying the whole letter and the whole idea of criticizing subjective responsibility. And this flaw is the statement that the developers, or even the developers, or those who apply AI, doesn't know how the systems work. And actually, if there is a problem that is related to that, is only the fact that some methodologies of AI, particularly those more complex as deep learning, has a difficulty in of opacity, of black box, and this means only that some of the outputs, for some outputs, it may be difficult to identify what are the relevant criteria. Okay, but this doesn't mean that that developers doesn't know what's going on, so everything involves an unsurmountable risk. So that's not really the case. And even though it may be difficult to specify a particular decision which would be responsible for a damage, it's possible to circumscribe in the chain of development of the artificial intelligence tool, which were the actors which were responsible for the decision-making in each chain of development. So who controls the risk in the development and the deployment of the AI. So this seems compatible with the regulation on subjective responsibility. So we wouldn't need a special objective responsibility here, and especially an idea of a general objective responsibility, as was suggested already. This open letter doesn't come to that point, but it attacks subjective responsibility by these terms, which I think are flawed. Thank you very much, Juliana. And I will make a small switch regarding the fact that Professor Georg Borges still didn't join us. So I would like then to present you Carrie Hyde-Vamond from King's College, UK. And she's going to approach a different issue. And Georg Borg is going to talk about this European document on civil liability for AI. It will then complement your talk, Juliana. But I'm going to switch, and Carrie Hyde is going to talk about the application of AI to the judicial system, which brings several implications. It also raises issues about responsibility, but have several implications to judicial practice. So please, Carrie Hyde, thank you very much for joining our seminar. And please, the floor is yours.
Thank you very much. I feel very privileged to speak today, and I'm sorry to be interrupting this flow that we have here, because it's been a fascinating discussion, and this is taking it slightly away from that, but I think you'll see that there are some common themes nonetheless. So I hope that you can see my slides.
Yes.
Yes, excellent. So what I want to speak about is the integration of algorithms into the justice system and how that, what that throws up in terms of issues. When I say judged by machines, obviously we have used sort of mechanisms to kind of work out whether someone is guilty or not guilty. You know, we have our formulas, our procedures, which we already use in law to make these kinds of decisions. And this research that I've been doing unpicks or tries to unpick where the lines are and how you might make, say, a policy decision to integrate algorithms into judicial decision making, how you might make that a reality, and what the issues might be in doing that. So today I'm just going to speak about a pilot study that I conducted and the limitations that I saw in the current approach with how we're looking at AI in the justice system, or indeed just generally how we look at AI. And I propose that legitimacy is an interesting way in which we can look at this to improve, you know, to facilitate essentially reform in these circumstances. And my method is to, you know, collect data, build a model and test it. And there's an empirical method. And then I want to speak about a kind of complex building analogy, which I think will help, and I'll speak more about that later. So in between 2019 and 2020, I interviewed a number of senior judiciary in the UK. And I also spoke to computer science academics, justice campaigners, policing experts, and legal academic. And I used normal social science techniques, qualitative interviewing to process this information. I also attended a 5-day sprint or hackathon, which is essentially where we try to develop a new product or a new sort of intervention by getting a lot of people together in one room. And that would be a kind of multidisciplinary kind of approach. And a 2-day Turing Institute conference in London about the decision support recommender systems. So this is the sort of primary, this is where I'm gathering my information that I want to speak to you about. And this, you can see there just a word cloud, that a very basic word cloud that was developed from the interviews that I had. So what did I perceive in the issues that we have in this kind of scenario? We're trying to speak about reforming how we make judicial decisions, how we make decisions in the justice system. And some things cannot be avoided. You can't avoid the fact that there are serious resource and time issues that are affecting the justice system right now. And the justice campaigner that I spoke to was very aware of this. Okay, so we have massive backlogs in cases in the UK. You could be waiting 2 years at least for a criminal trial potentially, and so we have this sort of environment which we're working in. We also
2 years would be heaven to Brazilian standards.
Well, I absolutely I understand that it's even more. You know, there's other countries like your own where there's even more delays in terms of judicial decision making. But on top of that, we can't avoid what we're learning now about human fallibility. You know, there's certain situations where it's been proven people are not making decisions on a logical basis. And this will apply to juries and judicial individuals. Even if you're a highly trained expert, you can still make errors. And in trials, you can have prosecutors using logical fallacies to support their arguments. So we have this awareness now that the legal system and the way it operates is not necessarily, it's not an ideal system, and we can't ignore that when we look at reform. And then we have these product, innovations machine learning, decision tree algorithms, Bayesian reasoning, argumentation. We have all of this in the environment, and a sense of urgency. You know, how do we deal with this massive backlog, which is affecting people's experience of justice so much? Another theme that emerged when I was doing my research was this resistance to change that is visible amongst certainly professionals in the legal environment. So when you spoke about the open letter, I haven't seen that open letter, but it didn't surprise me that there may be these kinds of themes, and I can't say the level of their objections because I haven't read it. But what we have is in the justice in the UK, at least through my research, is there's this feeling of there's an uncertainty here. Are our legal professions acting like a jealous guard of their their position in opposing reform? Are they acting out of self-interest or actually just a lack of understanding of the technology and a fear of that unknown? Or are they, and this is using terms used by Richard Susskind in his work, or they the benevolent custodians? Are they just looking after our interests by intervening and know best for us, as a whole? That's debatable, of course. But if we have this sort of stalemate where nobody is making a decision, and we have, these very skilled professionals creating a blockage, what we might see is a forced change if there's not proper interaction, where we just simply can't deal with the backlog of cases and we have to bring it in, just because justice itself is being impaired. So how do we unpick this? We need to unpick the genuine concerns from the experts in the field, and what would be the right thing that we're looking for. And I would say that we really want the function of the system to be our ultimate goal. Yeah, does the system work? Is it doing what it's supposed to do? And in handling this is a huge challenge because we have, expertise in computing and decision making. We have expertise in legal academics who are working in their sort of internal sphere of where, are these laws working, and is this allowed or is this not allowed? And then we have the policy literature and the decision makers, the policy makers, who are also trying to reach a resolution and move things forward. In terms of the current approach that we're looking at, there really is a problem in communication, and I think this is part of where our problems are coming. There's a lack of unified success criteria. Essentially, how do we know that what we're introducing is working? How do we know that that's a valid innovation, or whether it is impairing justice in some way? We know that we use sometimes incomplete proxies, things that are not equivalent to justice, for example, a number of cases processed. That's not equivalent to justice. So you have to be wary of these incomplete proxies. And of course, accuracy is not necessarily enough. Transparency is not necessarily enough. These are all things that may go some way to explain whether something is doing what it needs to do, but it's not necessarily complete. And when we think about terms like efficiency, which are obviously important in a limited resources, a scenario where we have limited resources, we really need to understand what is this output. This is a definition from the Oxford English Dictionary. Output per cost of the per unit cost of the resources employed. But what is output? Is that simply numbers of cases, or is that the quality of the justice experience? And how do you measure that? Okay, and when we talk about guilt, we don't know. We're working on, Lauren was saying the humans have bias, okay, and we know that the data that we're using has historical bias in it potentially. We can't be sure that those who were found guilty historically were guilty, and this is a problem with having a ground truth when we're doing using algorithms to make these decisions. And when you think about risk, and the European Commission's suggestion on what is high risk and what's not, you know, the risk there is beyond the level of the individual. It's not just the individual risk that is at stake, it's the actual system itself, right? So this is an example of the exam results protest in the UK. They used an algorithm over COVID because people couldn't have exams to make decisions. And what you had is a kind of what was being described as a case study in how not to implement an algorithm. Okay, you have massive people not trusting that algorithm, a lot of people against it, and that's what, you know, that's not what policymakers want either. Okay. And I'll just whiz through this one, but there is a real concern in academic scenario fields about this, and a recognition that there's that one of these scenarios, one of these sort of transparency or that you need to have a ethical dimension, you need a philosophical dimension. We need all of these things together, okay? And essentially, not even transparency or explainability can be a full answer. Ruben Bin's paper of 2018, it's treating a human like a percentage, shows that we have a lot of different explanations can be given. It doesn't necessarily translate to justice in the eyes of the person who's receiving it. So I've proposed a systematic approach, which is based on empirical measures, but grounded in this idea of legitimacy. And by legitimacy, I mean we can measure the quality of the decision making and the quality of treatment using a measure developed in used, for example, by Tyler in 2003, which was used not in an algorithmic sense. It was used more broadly in the criminal justice system to measure how people respond to the legitimacy of the system that they're under. Okay, and this can be tested then, exposing it to the public and to elite shareholders. And it's a kind of measure that can be replicated and extended. And just to explain a little bit more about legitimacy there, when the actor there in this scenario, when we speak about legitimacy, they're thinking about what is the quality of the treatment that I am receiving and what is the quality of the decision making. And that has a direct impact on their voluntary cooperation with the authorities and their adherence to the rules of behavior. What I'm trying to get across here is how important it is that people feel that they have trust, that they think something is legitimate. And this is not limited to algorithms and AI. It is a broader measure. It's something that can measure current justice and algorithmic justice. And that's the point. You can't look at things in isolation. You have to look at it more broadly. What I'm doing currently, my work currently, is I'm looking at two different case studies, one of which is a civil justice calculator. So it's a very simple decision tree algorithm. And I think this illustrates, again, the need to unpick what are we talking about when we talk about AI? What are we talking about when we talk about algorithms? When we have resistance in the legal sphere, sometimes it's due to a lack of understanding of these different terms. Okay, and if we have if you look at the affordability calculator, that's civil, it's very simple, and then a single justice procedure, which is another case that I'm looking at, another sort of case study that I'm looking at, that's criminal, and it's about speeding up this kind of process where we go from prosecution to potentially a guilty judgment in almost in an automated scenario. And I want to try and further automate it in my research to test people's responses to that kind of scenario. And in doing this is just an overview of my data collection process, but essentially I'm using qualitative, social, sort of social science approaches. So tried tested approaches. So what I'm basically saying is we need to get involved a variety of people when we're forming the model, okay? And when we use these social science techniques, I noticed there's a very similar scenario where you're taking into account various people's viewpoints. You might embed yourself in an environment and gather information from people, do your background reading. So you might do doctrinal research in terms of what is the legal process that we're trying to automate. We're also speaking to people on the ground and observing processes, and then interviewing. So it's a kind of holistic approach to try and build this algorithm. And it's quite natural then to go from, building a descriptive picture to then a kind of algorithmic picture of the same event. And through this, we can start to test where are the limits of what we think can be automated and what cannot. But it's important that it's a kind of collaborative approach. And there I'm suggesting that something like legal idioms and Bayesian approach, this has a lot of similarities as a computer science background to the kind of social science descriptive approach. It's not a long way away, although of course it's a different perspective. And then testing, my green box there, I'm going to take that algorithm, show it to public, use focus groups, see how they respond. And because we've got an empirical measure legitimacy, you can test to see whether this is resonating with people and what their problems with it are. And it can be an iterative process that goes back and checks again what people's responses to that kind of intervention is. So, what are the aims here? We really need, for policymakers, if they're going to make a sort of urgent intervention into the justice system to resolve some of these issues, they need to make informed decisions regarding reform. And when you look at risk, look at it in a holistic way. It's not a sort of, is it accurate, or are we getting through a lot of cases? And by using an empirical measure like legitimacy in the form that I've described, this is just not one perspective. It's taking into account legal perspectives. It's also taking into account the technical side, and it's allowing for a conversation, much like in a way that the hackathon kind of method, but through tried and tested social science methods, that have been established over a long period of time. And if we are, thinking about what can be taken away, well, maybe you can use it for case management and not necessarily ultimate decisions. There's various options, but we need to sort of look into these things in detail to be able to do that. Going back to that policy environment that I spoke to about the start, this process is, and I think it needs to be, even if it's not using exactly what I'm suggesting here, it needs to be agnostic as to the particular technology, because development will occur, okay? And something that allows a comparison with real life. We can't just look at, does this algorithm cause injustice, and call that the end of the inquiry, because there's injustice right now in the way the justice system is functioning. So we have to be aware of the real life scenario. And by bringing in human public perception, you link that to the society's, you link development of these kinds of tools to the society's perception of what is acceptable, which will change. What is acceptable will change as time goes on. And that's why it's important to link it to something that is not sort of written in stone, essentially. And now, just to finalize, I don't think this is an arduous process in terms of developing these models and testing them. It's natural. Perhaps it's necessary. And it's a way that we do this anyway. Yeah, when we think about algorithms, we think about processes. We almost create models in our mind anyway and see how it would play out. And I just wanted to speak slightly about this complex building analogy, which is from Gawande in his 2018 book, Checklist Manifesto. But the idea being that when we make decisions about complex building, like a sort of tower block, and we think, well, we need to install, say, water in this tower block. There's not one individual, no master builder who makes that decision whether it's right or wrong to include that, because their abilities, there's so many specialisms that go into construction of a complex building. There's so many schematics that are drawn up, have multiple schematics. And that just emphasizes, I think, what's been spoken about already, is the need for multiple, an interdisciplinary approach on this. You must have other people's voices included when you're making these kinds of reforms. And when I think about the structural integrity of that building, I'd say that's legitimacy. Yeah? We need the building to stand. We can't have a scenario where people lose faith in the justice system. As we were saying, trust is all important. And if you start to lose that trust, then the whole edifice can fall down. So we need that kind of focus on legitimacy. So that's I don't know if I'm all right for time, but that's my piece. Thank you.
Thank you very much, Carrie. There is some question from the audience regarding the adequacy of application of AI to substitute decision making by judges, which is the following. There are changes in jurisprudential understandings. I mean, this means there are changes in the decision making, which changes previous understandings in precedents. So this is a natural effect in the activity of a court. But nevertheless, artificial intelligence bases its provisions of decision on past decisions. So the questions by the audience is how could this be matched, or if the application of AI is going to create some sort of stabilization and make it difficult for innovations in the decisions of the court by the court.
Absolutely, yes. So the question has got a good point, that obviously the nature of law is that it's constantly developing, and cases which might seem at first minor can lead to major developments of precedent. And I think this is a really valid issue that needs to be taken into account as we push forward in using these tools. But I don't think it should stop us, because there's not just one type of not one type of innovation. There's not just one way of using these things. Absolutely, predictions that are based on past behaviors, so past decisions, will replicate those kinds of that kind of decision making. But when I look into things like Bayesian reasoning, which enables experts to create a framework and then apply, sort of each link of the chain essentially is a decision point. Yeah, so you could have elements which are decided through AI, and you might have elements that are decided through human intervention. And I don't think it's I don't think it's an ultimate barrier. I think that I'm not saying that it's going to necessarily happen soon, but I think that what we can do is try and unpick which elements of judicial decision making can be assisted. How can we be pushed out of these logical biases that fallacies that we might fall into? How can we improve judicial decision making in that sense, and through it, sort of potentially make it more transparent? So there's a variety of approaches, is how I would answer that. And I think that there's, certainly there's concerns with certain ways of doing it,
Thank you very much, Carrie. Thank you for joining and for your brilliant presentation. We are now going to move forward for the discussion. Again, actually, we are going to return to the discussion on civil liability of AI. I'd like to thank Professor Georg Borges for joining our seminar. Professor Borges has given a lot of thought on the issue of civil liability regarding AI. And previously, Professor Borges, we have a short discussion on the Brazilian proposal for the regulation of AI, where it suggests that the solution should be subjective responsibility and only in exceptionally objective responsibility for AI in those cases of risk. So it follows generally the European approach, but of course there are the Brazilian document is very superficial. It just indicates that future regulation should adopt subjective responsibility as a standard. We have had recently some discussion by scholars on the subject. So the subject matter is particularly relevant for us nowadays, given that our bill is on the Parliament under discussion, and it has raised the interest of several jurists here in Brazil. So I believe your talk will enlighten our discussion here in Brazil. I thank you very much for participating in this seminar, and the floor is yours, Georg. Thank you very much.
Thank you very much, Professor Maranhão, Juliano, for this very kind introduction. I'm really sad not to have this seminar online. I would have liked to go to Brazil for this, and I hope we will have the possibility to do such things again. Can you see I tried to see some slides. You should be able to see slides with the title AI Systems and Product Liability. Is that correct?
Yes, perfect.
So let me briefly introduce, not myself, that has been done by Professor Maranhão. I'm professor of civil law, and have a special interest in aspects of AI, in particular liability for AI. I'm managing director of the Institute of Law and Informatics at Saarland University in Germany, and we are heavily involved in education in the field of IT and law, and as well as in research in almost all the fields. Just this list of is demonstrating that we are involved in several projects, and some of them deal actually with AI and liability as well. Today, I would like to talk about the role of liability within the legal framework for AI systems, and then after a short overview, would focus on the European approach via the European Product Liability Directive, and again focus in the last part on one aspect which seems of particular importance in my view, and also try to reach a conclusion for it. What is the role of liability within the legal framework? It addresses risks associated with AI systems, and obviously there are numerous risks, among them the risk for safety or for danger of life even, were well illustrated, unfortunately, by the Uber accident some years ago. I think you're aware of that. Another topic which is demonstrating a risk associated with AI systems, I think very close to what Kari just has elaborated on, bias. Human judges may be biased. Unfortunately, machines also can be biased in some way. It's an interesting topic as well. What is new about AI systems, in my view, is the fact that they can show some what I would call behavior. Behavior in this meaning should mean that it can choose actions depending on a perceived situation. This is rather new. traditional machines were functioning well, but not depending on the given situation. They just had performed the same repeatedly function. And that makes it new and a bit unforeseeable. That's why we also talk about autonomous systems, just because there is some kind of unforeseeability of the direction. Also, machines equipped with AI can even be able to make decisions. I think the example of the moral machine published by the MIT some years ago, where expressed the so-called dilemma where a car might have to decide to whom to kill some pedestrians or its own passengers. I think you have probably heard about this, this example. The legal framework on AI is developing. In Europe, the European Commission is very active in the field since 2018, when it announced its communication AI for Europe. I would like to mention the work of one expert group that has been established by the European Commission in 2018. This is the expert group on liability and new technologies, which published its final report in December 2019. And that report has attracted the attention of the European Parliament, even, which published in October 2020, so 1 year ago, a proposal for a specific civil liability regime for AI, which was based on the work of the expert group. What we now have in this year, I think it has been reported almost globally, and you probably are informed about it, is a proposal for regulation laying down rules on AI, the so-called AI Act, which contains interesting rules on risk management regarding AI. However, it does not touch any liability questions, as this is expected to be published in the specific instrument in spring next year. We are waiting for this, for the proposal of the European Commission, and that will be certainly another important step in establishing the legal framework for AI regarding liability in particular. Now, I wanted to ask, what is the function of liability within that evolving legal framework for AI and AI systems? And we have to go back to the traditional functions of civil liability to understand it, which are mainly two. One is what we know as compensation for damage occurred. Civil liability grants the victim for a claim for compensation against the one who caused the damage, but also, and maybe even more important, with regard to the design of the legal framework, is its function to incentivize the addressee of liability regarding his or her behavior. This incentivizing function is the one which is discussed mainly in the field of law and economics, not so much in traditional lawyers' perspective, but it is the one which makes it interesting to be considered when we talk about AI system, and I will come back to this in a minute. Julian, you talked about concepts of liability when you made a contrasted subjective and objective liability. Unfortunately, I'm not aware what really subjective liability is. I would use the term fault-based.
Liability would be fault-based liability.
Okay, that's what I assumed. Yeah. So fault-based liability or subjective liability, as it was defined, is a traditional concept of liability, which we find in all jurisdictions worldwide, as it is the classic rule of tort law. The newer concept is strict liability, which has been introduced many years ago. It's also a traditional part of the legal framework. In the German Civil Code, we find strict liability in the number of cases. What is the difference between fault-based and strict liability? And the main is that fault-based liability requires there to be a breach of a duty of care to trigger liability, whereas strict liability grants a claim for compensation in the case of a damage within a defined sphere of risk. So a breach of a duty of care does not have to be established in the case of strict liability, which makes it so much easier for a victim to receive compensation. Another important aspect in regarding the concept of liability for AI systems is the question, who will be the addressee of such a liability? We have to distinguish in the field of AI the strict liability addressing the operator of an AI system, which is the traditional solution in the cases we know, and on one hand, and producer as a potential addressee of liability. And the example of product liability is indeed addressing the producing. However, it's not strict liability in a narrow sense. I will come back to it in a minute. For the reason that product liability is the one traditional concept of liability, even so-called strict liability, which addresses the producer of an AI system, I would like to go into some more detail in analyzing the European Product Liability Directive and their application on AI systems. The Product Liability Directive dates back to the 80s and was and the Article 1 is stating the concept and establishing a claim. The producer shall be liable for damage caused by defect in his product. This rule can be applied to AI systems without any doubt, but we have to ask some questions. For instance, such as, are AI systems really a product? The question whether software is a product was debated for decades, as Article 2 of the product defines product as a movable, so as a thing which you can touch, and software is not a movable in the sense of Article 2. However, despite the more narrow definition of Article 2, at least in literature, software is being regarded a product nowadays. So in that case, a product liability would apply on software and would address producers of software. If software is a product, then the functional unit of a neural network and software also is a product within the meaning of Product Liability Directive. And of course, any movable in which such a functional unit is placed will necessarily be a product as well. So self-driving cars, to give an example, is obviously is a product within the Product Liability Directive. The producer of such product, of such AI system, is the one who is manufacturing the product. So in the case of software, the programmer would be part of a producer. In the case of a neural network doing machine learning, the one who is doing the training should be regarded as a producer. For all these requirements and elements of liability within the European Product Liability Directive, the definitions can be applied to new technologies such as AI systems. The more difficult question, however, is how we deal with faulty decisions. In my introduction, I said that AI products are special and different from traditional machines as they can show behavior. And the question is whether conduct or behavior can be regarded as a defect of a product, as product liability requires there to be a defect of the product to trigger liability. A defect is defined in Product Liability Directive as an insufficient property of a system. Conduct or behavior, however, is not a property of the system. And also, product liability is not a liability for faulty behavior of an AI system. So the question is, how can we relate a damage which has been caused by faulty behavior or conduct of an AI system, such as an autonomous car, for instance, to the requirement of a defect? There is a bridge to this. We can define the ability to behave in a certain way as a property of the AI system, not the behavior as such, but the ability to behave in a given way that can be defined a property. And if this does not fulfill the requirements, that property will be defective. Now, let's ask ourselves for a moment what the reference point of defectiveness of an AI system should be like. I said the ability to behave in a certain way can be regarded a property and a potential defectiveness. But what is the reference point, let's say, in the case of a self-driving car? Should it be human behavior? At this moment, we don't have any rules for as a reference point for the defectiveness of AI systems. So intuitively, we probably would refer to human capabilities. However, this is not adequate. If you think of the example of a self-driving car, limiting the expectations to a self-driving car to what a human driver might be able to do would certainly not be enough. It is the benefit of a machine that, for instance, can react faster than a human. That's why if we want to correctly and satisfyingly apply the rules of product liability to AI systems, there will be a need for machine-oriented expectations on machine behavior, or if you want to address it as a property, to machine-oriented expectations on the machine's ability to behave in a given way. And then as we start to specify our safety expectations specific to AI systems, the question necessarily arises whether we can expect an error-free AI system. That would be nice to have a self-driving car who would never make any mistakes. However, the expectation of an error-free AI system would result into what I call objective or causal liability, which is not established by the directive. The directive established as liability for a defect of a system, not for a causal liability which is triggered by any damage. So error-freeness can never be the expectation. Instead, there must be some kind of fault tolerance of an AI system, and that has to be determined, be specified. And second, after we know what kind of or what degree of fault tolerance we can expect from an AI system, there should be a way to establish the existence of such, or the satisfaction of such expectation, and that creates the need for testing of AI systems, since only by testing we can really find out to which degree an AI system will behave properly behave in a given situation. That's why in the current discussion, the testing of AI systems is in the core of the legal framework. You will find reference to testing of AI systems also in the AI Act, where it is a part of the risk management required by the draft act. The last element which I want to mention is the burden of proof. Under the Product Liability Directive, the victim is bearing the burden of proof for the defect of the system, and that is a difficult task for a victim, in particular in cases where there's no such thing as a pretrial discovery. Under German law, for instance, the victim has to establish all the facts for this case, inclusive of the defect of an AI system, which he cannot analyze himself. For this reason, the expert group, which I mentioned earlier, suggests a shift of the burden of proof in certain situations. And the question then is, in which situations such reversal or shift of the burden of proof should be triggered? I suggest in my paper, which was published in the Icail proceedings, that there should be a reversal of the burden of proof for defectiveness or proof in the case of faulty behavior. So we would come back to the link between behavior and property. Once we can establish faulty behavior of an AI system, let's say an autonomously driving car, there is an assumption for defectiveness, which would make it much, much easier for the victim to bring the factual basis for his claim to the court. Since in this case, after establishing faulty behavior, the producer of the AI system would have the burden of proving that the AI system was meeting the safety requirements. And that's basically it. I come to a very short conclusion. Product liability can be applied in general to AI systems. However, we have to make some amendments by way of interpretation in order to adequately apply it to the case of an AI system. One of the challenges is the definitions of the expectations regarding the AI system's ability to behave properly. Is it zero or error-free safety, which is not the case in my view, but the question then will be what kind of degree of error-freeness or accuracy can be expected from an AI systems. And another challenge certainly will be the proof of a defect. Here I suggest a solution, which is a shift of the burden of proof for defectiveness in the case of faulty behavior. And that's it. Thank you very much.
Thank you very much, Georg. Excellent presentation, which really synthesizes many of your thoughts in different articles or in papers that you have where you have developed this idea. I have one question, two questions actually, and there are questions from the audience too. One of the questions is. You have a nice proposal of inversion of the burden of proof when you detect a faulty behavior, and then the developer of the AI system has to then show that no faulty has occurred. The AI Act, the European AI Act, the proposal, has a list of risk management systems and government procedures that will be obligatory if the document comes into force. Do you think that a company could show a duty of care in their defense by also reverting again the burden of proof if the company shows that they have followed and complied all procedural measures regarding the best governance of AI as established in the AI Act? This is one question. The other question is actually an invitation to discuss. In Brazil, especially regarding consumer protection. There is already an inversion, a reversion of the burden of proof, just if you show damage. So the consumer wouldn't have to show a faulty or behavior by the AI system. So the second question is whether you think this would be an exaggeration that would put too much burden in the companies developing software. So these are the first two questions. My questions, I'll then turn to the questions by the audience, and then I can make them for you. Please, first these two.
Thank you very much for the super interesting remarks and questions. The first one, what is there a reversal of the burden of proof once the company can establish that they exercised reasonable care, or that they fulfilled all the duties of care? In my view, we still have to distinguish fault-based liability and product liability, which is a kind of strict liability. So I would not say you have a reversal of the burden of proof just because it can be demonstrated that you fulfilled all the requirements under the AI Act. However, as a part of the risk management requirements, testing of AI systems should be properly tested. And if the tests would demonstrate the reasonably accuracy of the system, that would work as a proof of non-defectiveness. So I would turn it this way, that the proper testing is the way to demonstrate that the system reached the required degree of accuracy. So it would even be some kind of easier. Second part, a reverse of a burden of proof just in the case of a damage. That certainly, that can go too far, since it's what you have to demonstrate. I mean, what is the counter argument? The defectiveness, or is it fault based, that there's no fault in the meaning of the breach of a duty of care? I guess that in the case of the Brazilian consumer protection law, the reverse of the burden refers to fault, so that the company would have to demonstrate that it didn't violate any duty of care, probably. That applies in contract law also in Germany, actually. So the same systems applies to contracts, however, not to tort law and product liability, since we traditionally think that would go impose too high liability risk on the producer, actually. So the compromise establishing a kind of damage is not enough. There should be something more. That's why my suggestion then stepped in, saying the misconduct or faulty behavior should trigger the reversal of proof, not the mere existence of a damage.
Okay. Yeah, I think I agree with you. And there is a question by the audience here. In Brazil, there is a decision by the Supreme Court which establishes that software in some cases is a product, but in other cases may be a service. So when it is largely distributed, it's a product. But when it's requested by a company, for instance, it is developed by request, and therefore it is a service. So given this distinction, how would affect your reasoning in the development of your ideas regarding responsibility? For instance, when you consider software as a service.
Yeah, thank you very much. This distinction has been discussed in European law as well, and also in the context of a product liability directive. I don't know if the European Court of Justice would still follow this distinction and take individual software out from the product liability. This is hard to expect. In my view, it should not make a difference, since in case of other products, even individually developed products are subject to the product liability directive. So it's hard to see why there should be exception for software actually.
Okay. Thank you very much, Georg. I think there are no more questions from the audience. I'm also pleased with your answers, and it gave me some more food for thinking about these issues. And I would like then to
thank you very much.
Our seminar, and thank you all speakers very much. I think it was a very rich and interesting encounter. We could develop several ideas and points of view which will centrally illuminate the discussion, which is quite hot in Brazil nowadays, given the discussion of the Brazilian bill on AI. And certainly the discussion will receive insights from the European discussion, since it was much more, the European discussion is much more mature than ours. So I hope that logarithm is going, I do not hope, I know that logarithm is going to promote and organize further events to bring the international perspective, the perspective of other jurisdictions in these important discussion for the future of society and of economy, or actually for the future of humanity. So thank you all very much. It was really a pleasure. And by saying that, I close this seminar and hope you follow the seminars and lives by Logarithm on the discussion of AI. Thank you very much.